I'd like to introduce our next speaker, Michael Carroll. Michael is a professor of law and director of the program on information justice and intellectual property at American University Washington College of Law. His research and teaching specialties are intellectual property law and cyber law, focusing on the search for balance over time in the face of challenges posed by new technologies. He's a founding member of Creative Commons, which Scott talked about extensively, a global organization that provides standardized legal and technical tools to enable legal sharing of cultural, educational, scientific, and other copyrighted works. Michael is also recognized as a leading advocate for open educational resources and open access to the research that appears in scholarly and scientific journals. In addition, he serves on the board of directors of the Public Library of Science, PLOS, and recently completed service on the National Research Council's Board on Research Data and Information, and is an academic fellow of the Center for Democracy and Government.
Thanks very much. Good morning, everyone. Good morning, everyone. We've all had our coffee. I'm going to speak a little bit quickly to go through some slides, so strap in. And I am here in my personal capacity. I'm not speaking for the Public Library of Science or for Creative Commons, so just so we're clear about that. And I'm a copyright lawyer, and I'm a copyright professor, and I'm looking at the change in the system and sort of asking whether copyright's doing its job, and whether we need to change copyright law, or whether we just need to change copyright practices to adapt to the internet. And I think it's more the latter, that it's really about copyright practices around scholarly publishing that are under change, rather than the need for new legislation. Oh, sorry. The environmental change that I have in mind is the way in which changes in behavior led by, the Margaret Mead small group that wants to change the world leads to the institutionalization of new practices. So if you think about our behavior with recycling, there was a time there, some of us are of a certain age, and so you can remember, let's go back 25, 30 years ago, people thought that we needed to steward the resources of the earth differently, and so we'd get up on Saturday morning and we'd tie our newspapers into bundles and put our cans in a bag, and then go burn some fossil fuels so we could go to the recycling center, because we had a vision for what responsible behavior looked like, and this was done on an individual basis, but it was hard, and so only a small number of us were doing that because that behavior required this sort of individual initiative and this vision. But over time, the values that underlay that behavior became institutionalized, and now we're expected to recycle. Many more of us do, because the institutions around us have made that behavior natural, normal, and easy. And I think sort of publishing in a way that takes advantage of the capabilities of the internet, we're in the same sort of behavioral transition, where we're still in a system where many publications are being published under restrictive terms, or not freely available on the internet under terms that allow for maximum reuse, and therefore we're losing some of the opportunities that we might otherwise have. As you may have seen recently, there was an article about, it was known that there was Ebola in Liberia. It was published in the 80s, but you would not know that if you did a Google search, because those articles were all behind paywalls and not freely available. So when the outbreak took place, we were in a world where researchers couldn't quickly learn what we should have already known, because it was published, but not publicly available in an environment that we currently operate in. So as a copyright lawyer, I want to give you a small bit of sort of larger context around copyright and publishing. Copyright's in the Constitution, and it's in the Constitution for a reason. When the Founding Fathers gave Congress its different powers, most of the time it just said, yes, you can do this. In this particular power, there was a reason given for it, and it's to promote the progress of science and useful art. So copyright is a tool toward an end. And you can see that there's an implicit economic theory in this grant, that in a world where publishers and authors are creating expensive printed artifacts that take a lot of money to print and distribute, you need to create some exclusivity around that in order to get a return on investment to promote that activity, which in turn promotes progress of science and useful arts. I'd suggest with the internet, the economics change a little bit, not all, but some of the economics of that theory change, and so we should keep the ends in constant, progress of science and useful arts, even if the means, full exclusive rights, may not be the appropriate means anymore, and that's what we're going to talk about. And the Supreme Court has made it clear that in the United States, we don't treat copyright as a natural right, or individual copyright as a utilitarian tool to achieve this larger aim of progress of science and useful arts. And outside the United States, that is less true. So copyright started as a fairly modest thing. The way we copyright lawyers think about copyright or all intellectual property is that it has three dimensions. What information is covered, right? What are the rights? So the verbs, what activities fall within the intellectual property right, and how long does it last? So originally, copyright just applied to maps, charts, and books. If you were a visual artist, you were not in the copyright club. Anyone could copy your painting without you having any legal rights because you were not part of the subject matter of copyright. Over time, the list has grown, and now any original work of authorship is copyrighted. And that, for those of you dealing with data and data sets, that expansion has created a little bit of complication around data because the underlying facts in a data set are not copyrightable, but the selection and arrangement, if it requires some creative judgment about how to name the fields and organize them, there may be a little copyright layer that only attaches to the original part of that. The underlying data remains in the public domain, so anyone who comes along and comes across that data set can extract the numeric values, but they cannot copy the data set or the database as a whole. We've moved from 2 14-year terms to the life of the author plus 70 years. That means things published prior to 1923 are in the public domain. After that, you have to check, because we were in a world where you had to renew copyright for a long time, and the majority of those copyrights were not renewed. So a lot of post-23 materials, if you're looking at your own back files and wondering what's in the public domain and what's not, it's messy because it depends on whether somebody renewed copyright or not. As Scott mentioned, copyright is actually a bundle of rights. These are the different verbs. This is what you get when you get a copyright. What's the shower thing for? Well, once upon a time, you had to opt into the copyright system. You had to register your claim to copyright. You had to put Circle C on it. If you published without Circle C, it went straight into the public domain in the United States. In 1989, we got rid of that. So now, at the moment the work is created, these exclusive rights shower down upon the author. And copyright is territorial. So this is, you don't get one copyright when you create. You get a United States copyright. And then by virtue of our treaties with all these other major trading partners, we automatically extend copyright to foreign nationals, so that what's showering down upon you if you're writing an article in the United States is about 190 copyrights. And those copyrights come with the exclusive rights subject to limitations and exceptions that vary by national law. And Scott alluded to that a little bit, and it comes up currently in the scholarly communications environment around text and data mining of the published literature, where most of that activity is covered by fair use in the United States, but there's a lot of energy in Europe around that because they have much more restrictive limitations and exceptions, and in England they actually had to pass some legislation to make it clear that text and data mining is permitted. So there we are in fair use and first sale. First sale, once you sell a physical copy, you can no longer control the redistribution of that physical copy. It can be resold without any copyright restraints. And fair use is a balancing test that determines whether the use requires permission or would promote the progress of science and useful arts without a license. And that's the goal of fair use. All right, so I've said that. But we're in a world now where the presumption of control applies to all copyrighted works. So the theory is all authors need the exclusive rights in order to do their job and promote the progress of science and useful arts. But as Scott just demonstrated, under that theory, we shouldn't have open source software because none but a blockhead writes for money, said Dr. Johnson, but people are writing code and giving it away. Why? Because one size doesn't fit all. The motivations of a creator vary depending on what they're doing. And so the standard bucket of copyright rights works very well for people in certain industries and who are using certain publication models, but not all. Right? And we talk about it as intellectual property, which is the perspective of the owner of those exclusive rights. But from the user's perspective, copyright is the terms of use, and copyright sets the default on what the terms of use are. But you can use licensing to change those default terms of use. And usually those licenses have been negotiated bilaterally between parties providing specific permissions. But open source software licensing and then Creative Commons licenses are what are known as public licenses. It's a one-to-many license, right, that changes the terms. And it's all about the internet. It's all about the fact that those verbs that copyright controls used to be verbs that only other commercial entities had the capital to do, to reproduce and distribute physical copies of text or records or movies in analog media required a lot of capital. But the internet creates all of these capabilities. All of us can be publishers, republishers, adapters. So the question is now, the technology gives me a lot more power to promote the progress of science and useful arts by sharing knowledge more quickly, by email, by a blog post, etc. But the verbs that copyright controls say that I'm not allowed to use these technical capabilities because the law says I can't. And I'm just going to footnote this for all of you who take copyright assignments from university faculty on the assumption that they are the authors and they own the copyright. Just understand that the entire scholarly publishing industry sort of sits on a legal fault line where that might not be true. It might be that those faculty actually have no rights to give you, because it may be that those are all works made for hire and that their employing institutions are actually the authors under US law, and that you would actually be needing a license from the university. It's as if I, a faculty member, were selling off my office chair. I don't have the rights to do that. So nobody's taken this case to court at the highest level. It's sort of bubbled up here and there, but just be aware that there's a huge elephant in the room in terms of who actually is the author of faculty-created research articles. And there are faculty university policies that purport to deal with this, but in my view, they don't really. The law's got technicalities that those policies don't fully conform with. So at some point, this case may arise, but just be aware that there's a risk in the entire in the entire system when people are relying on faculty to be giving you the rights that you're relying on, and naming that you can only give what you got, and they may not have any rights at all under US law. They need to on the faculty method. Okay, so the tradition has been to sign away the copyright in exchange for publishing, and that means that if I wanted to access this article in Cell, I can't do it. I have to pay $30 to get copies or translate that, right? Access denied. We live in a world in which a reader wants to get access to this content, but because the copyright is transferred from the author to the publisher, when the publisher charges for access, we live in a world where the internet would make it easy for me to get access to that information, but the publishing model does not. And so open access says, can't we all get along? Isn't there a way where we can pay for the costs of publication, which are definitely not zero, but do it in a way where we can maximize the capabilities that the internet allows to promote the progress of science and useful arts? Right, so Scott's already given us some of the sort of what of open access. The why, from my perspective, is that there are at least 5 audiences that open access publication serves that the subscription model doesn't. So one is what I call serendipitous readers. I need a better term, but I'm talking about the fact that I'm a faculty member at an institution that has a subscription to your publication, but I use Google. I'm just browsing the web, and were your publication available online and indexed by Google, the researcher would find the article. But in the absence of that, they're not going to go through the subscription or through the university's website because they're not formally doing research. They would have just stumbled upon the article by following a link from a blog or something like that. So there are lots of ways in which even people with paid access don't actually get access because they're not part of the larger web ecosystem. And then, of course, there are readers who can't afford subscriptions, right? So you've heard from the librarian at Harvard, we're the wealthiest, largest academic library in the country, and we can't afford to subscribe to the entire literature. That's a problem. And of course, you know, what should I subscribe? In a world of constrained resources, which subscriptions should I get? As knowledge disciplines are shifting, you know, libraries try to respond to the different faculties, but what those faculties are studying is changing, and so there may be relevant literature to a researcher that's in an adjacent discipline. Nobody thought to subscribe, and therefore the researcher doesn't find that. Were they doing an open web search, they would find this article from the adjacent discipline and say, oh, aha. So we're missing some of those ahas that interdisciplinary research promotes, because we don't have interdisciplinary access. And of course, it's a global research community, and the web is a global resource, but in the absence of open access, these are readers. And then last, and to me, one of the more important audiences is the machine reader. You know, all of us faculty are suffering from information overload. More access, you want me to have to read more articles? It's already hard enough to keep up, right? But we could be using the power of digital technology to help us make better decisions about where our very limited attention ought to be spent. And there are ways in which machine readers could help mine information from the literature to help us understand what the current state of the field is. But you need an open access sort of source of text in order for these algorithms to be developed and perfected. And right now, even with Crossref, there is not a way to assess the literature as a whole. And so text and data mining is sort of in this chicken and egg situation. People say, well, you haven't proven that it works, and the researchers say, I can't prove it until you give me access to the entire corpus. But I would suggest that IBM's Watson and other sort of intelligent algorithms certainly may give me the inference that if you give it enough data, it can, you know, the kinds of inferences that can be drawn from large amounts of text are quite powerful. So in a world of text mining, a statement like this, the machine, you know, the humans are going to read this, and if you're in this discipline, that sentence makes sense to you. If it doesn't, it won't. But each of those have conceptual, sort of semantic meaning, and we could break that down and then look for linkages across the literature. But unfortunately, and let me just say, in the United States, if I have access to your text, I can do this without your permission because that's a fair use. I'm not making any copies that compete with you. But in other parts of the world, even the little temporary copy that my machine would make for the purposes of extracting the non-copyrightable information out of the literature would violate copyright. And so that's why in England they had to make it an affirmative right. But just because I have a fair use right to do it doesn't mean I can't license away that fair use right. And in fact, many publishers demand that academic libraries that subscribe to publication give up text mining rights as a term and condition of access. Again, hobbling the power of digital technology because there's a theory that there's a new business to be had in selling text and data mining rights. But I would suggest that just isn't right because text and data mining require access to the full literature. I don't know what just, where we go. That was just my pause for a minute. All right, now, So that's the environment. That's the environment. You can see that I've got a clear bias in terms of the ways in which I think the internet is not being used and ought to be used. But I'm an economic realist about the value of publication, and I know that publishing needs to be paid for. I just think there are different ways to finance it. But let's talk a little bit about the copyright side. I've come to this seminar for the last 3 years, maybe. Tim's been kind enough to invite me, and I've done the roundtable on copyright, and in my interactions I realized that people have different levels of understanding about copyright. So if you already know this, I'm sorry for the repetition, but a few things to lay the groundwork. So copyright is that bundle of rights. You can either license through an exclusive license and transfer the rights, meaning that the copyright owner gives up their own ability to exercise copyright. That's what a transfer does. Or you can simply give a non-exclusive license, which is just permission, and in which case the copyright owner retains the right to do that. Under US law, for a transfer to be effective, it has to be signed by the author. It has to be signed by the copyright owner. So many of you have publication agreements. If that agreement does not get signed and you publish, legally, what just happened? What happened is the author still retains the exclusive rights, but you will have gotten an implied license because clearly the author intended for you to publish. So you're legally publishing, but you don't own all of the rights. If you want to own the rights, you need to get them from the author, and it has to be done in writing. The complication in science is that you need to make sure that the author is the author from copyright's perspective and not science's perspective, right? I might have a paper with 8 authors on it, and the corresponding author may be the leader of the research team, but that person has no copyright rights if they didn't write the text. It is the person who wrote the text that gets the showering down of the exclusive rights. So that's the person who has the power to license. Now possibly, if they gave the corresponding author the permission to act as their agent, essentially, in licensing or transferring copyright. But so, you have to look at your copyright transfer forms. If you're taking copyright, make sure you're taking it from somebody who's actually got copyright to give you. So IEEE registered. I don't know if IEEE is in the house, but this is an example of a typical form that requires transfer of copyright. Talked about that. And we know that many journals have more than one agreement. The opening bid is give me all your rights. If the author pushes back, there's often a second agreement, which is just entitled a license to publish, which is either an exclusive license to publish and commercially adapt for some period of time or not. Let me just raise another issue that's out there that is not as well understood as ought to be. Under the principle that you can only give what you got, there is an increasing amount of licensing that takes place prior to the signing of that publishing agreement. And some of this has been going on for decades and has not been fully recognized in the publishing industry. So under the US law, I can give you a license to something I have not yet written yet. Okay? And what the funding agreements by the US government have required for years is that the United States agency that funds the research gets a copyright license to use the work. So every time you take full copyright, if that work was funded by a US agency, you're not getting full copyright. You're getting full copyright minus the government's license. If your publishing agreement says, give me all copyright, then you're actually asking the author to make a misrepresentation, because the author actually can't give you full copyright, because under the terms of the funding that caused that copyrighted work to get created, they already gave a license to the government prior to coming to you. So they come to you with the license already having been granted. I've learned that you cannot read and listen at the same time. The auditory channel that uses the same things to it. So that's the point. Right.
Yeah.
And this is the key point. the government or the funding agency or the university that has one of these policies receives their license the moment those rights shower down. They shower down and the license gets transferred. So when the author comes to you with their bucket of rights, it's minus the license. And now there's more than one license. So if I'm a faculty member at Harvard, as if, and I got funded by NIH, I gave the government a license and I gave Harvard a license to take my final manuscript and put it up online, and so it's only what remains that I can transfer to the publisher. And those are those points. So, I mean, the language of the government's license this is one version of it, but the agency has the right to reproduce, publish, or otherwise use, and to authorize others to, if the use is for federal purposes. And we've got Harvard, MIT, University of California, a number of other institutions that say we, the library, should have a copy of your article and should be able to make it publicly accessible through an institutional repository. Right. And you know, I haven't even updated this, but the number of these policies coming online has increased. All right, in 5 minutes we're going to go into overdrive now. So the government, just in case, all right, as you may know, all the funding agencies that have $100 million or more of external funding are now required to come up with a way in which the research they fund will be made publicly accessible. Those public access plans are all being made publicly available as we speak. How they're going to specifically deal with copyright, it remains something to be determined, but they will have to ensure that the author's version of research that they fund gets up online. And so the number of adaptations to your publishing license may need to increase depending on which agencies your authors are funded by. And I'm going to push through this. All right, so we've talked a little bit about open access publishing. And the key here is that if we're talking about an open access publishing model, we're talking about switching the financing from the demand side to the supply side so that you can make the article free for use on the demand side. So a full open access publication pays for the cost of publication from the supply side. And it's not really the author, it's the funder of the author that is supplying that money, or there are indirect ways to finance that. This is a so-called gold open access publishing model, and it uses Creative Commons licenses. We've talked a little bit about Creative Commons. So the way we created these is, because copyright has a default set of terms of use, you want to change those, but you want to hold on to some control. What control do you want to hold on to? So do you want to be given credit? Do you want to demand other people relicense under the same terms? Do you want to limit the permission only to non-commercial use? Do you want to limit the permission only to copy-paste reuse? So these conditions combine into 6 permutations. So the CC BY license that you were hearing about is just the most open of those permutations. You can do anything you want with this as long as you give credit. One thing about the credit requirement that publishers should pay attention to, that we changed it in version 1 of the license, it was give the author credit. It is now give credit as the licensor designates. So a publisher using the CC BY license can say to the author, we must agree that the attribution requirement will be that you get credit as the author and I get credit as the first publisher, right? So, and then ideally what you should do is supply a preferred citation that says, you know, by author, first published in journal, so that the attribution is given both to the author and the publisher. And then if that is the attribution requirement, then any licensee has to reproduce both the author's name and the publisher's name to stay in compliance with the license. So there's a way for your reputational interest to be captured on using the CC license. The only other thing is the attribution cannot be done in a way that implies endorsement. So as Scott was suggesting, there are ways in which I have to give you credit, but not in a way where I'm sneakily suggesting that you're endorsing my use. And so that's baked into the license as well. We also have ways to give up your copyright entirely, or to simply label something that was already as copyright as such. And we try to make this accessible so the human, what we call the human readable deed, sort of describes in general, here's what you're permitted to do subject to these conditions, but the license itself is the lawyer readable text that sits underneath that. And that's about how many Creative Commons licenses. We cannot measure perfectly how many objects are out there. What we can do is measure links back to our license page. So that's what this 800 million figure is reflecting. So you've heard, the Public Library of Science helped demonstrate that there is a new way of financing publication where you move the money to the supply side, and on the demand side you give full reuse, because the theory is there's no reason to hold on to additional control other than attribution, because all of the costs of publication have been paid, and we want to maximize reuse to promote the progress of science and useful art. So yes, even commercial republication of PLOS articles is permitted. PLOS understands that, and by all means, if you can find a market where someone's willing to pay, then that suggests that you've added some value that they're paying for, because otherwise the article is free on the web. So if they're paying you, you've come up with something, and more power to you for doing it. One other thing I would suggest, because I know we have a lot of societies in the room, and there are people who say, well, that's fine for those well-funded biologists who have a lot of money from NIH or the UNICEF. They can pay, a couple $1,000 to, or $1,500 to publish, but my folks, the members of my society, don't have that kind of money. Well, here you have to really, the deeper thing that I hope we can do more in Q&A is what exactly are the publishing services that these authors need in this new environment? They don't need us to print and distribute printed artifacts. We're now in the database business, right? We're creating digital data that we're now making available over the internet. What is it about that digital data that needs a publishing service, since they can all mount their own article on a web server without us? So we have to be adding some value. And thinking about the cost of that value and the ways to make it more efficient, I suggest that one of the ways in which some of the publishing, there's a number of open access journals that don't charge on either side. And then you say, well, where's the money coming from? It's coming from indirect costs. The library publishing services industry is emergent, and there are ways in which some societies are coupling with their libraries to handle the cost of publication. University of Pittsburgh Library is one of the leaders in this, and so have a look at the University of Pittsburgh's library's website to see some of the creative journals that they've mounted on behalf of some of the sort of smaller societies. So I agree that we are in a world where publishing services are still needed, publishing services need to be paid for, but I do worry that people overstate how much money it costs in a world where the internet makes a lot of these costs cheaper, and the editorial services may or may not need to be the same. It depends on both the authors and the readers and what their expectations are. And with that, I think I shall end. So thanks very much.